Hello, and thank you for joining us today for this podcast. I'm Stein, a partner in Troutman Pepper's health sciences practice. I'm joined by my colleague Allan, also a partner in our health sciences practice. Today, Allan and I are going to talk to you about a recent decision involving the Anti-Kickback Statute and the RICO statute that has the potential to be a pretty big deal for companies through the healthcare space, if other courts were to follow it. The case, in re EpiPen direct purchaser litigation out of the District of Minnesota, the plaintiffs in this case are a group of drug wholesalers who bought the allergy product EpiPen from a company called Mylan. The defendants in the case are Mylan, which is the manufacturer of the EpiPen, and CVS Caremark, Optum Rx, and Express Scripts, which are pharmacy benefit managers, or PBMs, that had rebate contracts with Mylan for the EpiPen. The wholesalers are alleging that Mylan and the PBMs entered into rebate agreements with each other where Mylan paid the PBMs increased rebates and fees in exchange for them maintaining the EpiPen's preferred formulary status, and that as a result of the list price of EpiPens was wrongfully inflated. And since the wholesalers paid the list price or close to it, they're claiming an injury as a result. The wholesalers allege that these rebate agreements between Mylan and the PBMs violated the federal Anti-Kickback Statute, among other laws, and thus RICO. Okay, so Allan, this case goes into pretty specific details about the drug supply chain and the contacts between drug manufacturers and PBMs. We're here today talking about this case, so why does it have the potential to be such a big deal for companies throughout the healthcare space?
Yeah, Cal, so the short answer, and the reason we think this is a case that's worth paying attention to, is because it adopts a theory that, for the first time, allows private parties to sue over alleged violations of the federal Anti-Kickback Statute.
Right. So while this case doesn't necessarily create a private right of action under the Anti-Kickback Statute, it seems to come pretty close.
And if that's true, and if this case does open the door to private lawsuits to enforce the AKS, that is a big deal. That could affect companies across the entire healthcare industry, not just in the drug supply chain that the facts of this particular case are about. So really that means that this is a case that any company that has to think about AKS compliance and risk could be affected by. Right now, the main way the Anti-Kickback Statute is enforced is through lawsuits under the False Claims Act. And that statute can only support suits by QTAM relators and the DOJ. And those cases have to meet a variety of procedural hurdles. And of course, it's possible for the Department of Justice to directly prosecute a violation of the Anti-Kickback Statute, but that's rare. So a private right of action that allows private parties to bring lawsuits alleging anti-kickback violations would be a big deal. So let's talk a little bit about the legal issues in the case.
Sure. So the lawsuit here has several claims, but the one we're going to focus on here is the RICO claim. And to understand the RICO claim, you have to understand the interaction being alleged between three federal statutes: RICO, the Anti-Kickback Statute, and a third called the Travel Act, and I'll go through each of those. So RICO, or the Racketeer Influenced and Corrupt Organization Act, was originally passed to combat organized crime, but has become a somewhat common statute for prosecutors and civil litigants to use in a wide variety of litigation and circumstances. Briefly, RICO applies to two or more entities called a RICO enterprise that act in concert to commit a pattern of racketeering activity, which is at least two of the enumerated racketeering acts in the statutes. The Travel Act is one of the statutes identified in RICO, the violation of which constitutes a racketeering act. It's a federal criminal statute that, among other things, prohibits using the mail or any facility in interstate or foreign commerce with the intent to carry on unlawful activity. For the purposes of this case, it's important to note that unlawful activity under the Travel Act does include bribery in violation of the laws of the United States. The Anti-Kickback Statute is a federal statute that prohibits the payment for referrals of medical services that are payable by federal health care programs, most notably Medicare. So it's the interaction of those three statutes that's at issue in this case. And Allan, what was surprising to me is that this does seem to be a case of first impression. At least that's what the parties and the court thought, since they didn't really cite any precedent directly on point. So it's a really unique case. What else did you see in the case that made it unique to your eyes?
Well, that's right. That is the most salient, unique thing about the case. Both of these statutes, RICO and the Travel Act, have been around since at least the 1960s, and the plaintiff's innovation here was to put all three statutes together in a way that it seems nobody has done before, and the court bought it. The plaintiffs had factual allegations here that, allowed them to at least plead an AKS violation enough to get past a motion to dismiss in this court. But the Anti-Kickback Statute, again, doesn't offer a private right of action. So the plaintiffs couldn't have simply sued, alleging that there was a violation of the Anti-Kickback Statute that harmed them. For that, they had to turn their attention to RICO, which does have a private right of action, meaning that any private plaintiff who says it's been injured by something that the statute prohibits is allowed to sue and recover damages. And RICO is one of those statutes. But RICO does not list violations of the Anti-Kickback Statute itself as one of the predicate Racketeering Act. So plaintiffs couldn't simply say, a violation of the Anti-Kickback Statute is a predicate for RICO liability. For that, they had to turn to the Travel Act, the third statute. That was the creative part here. RICO does enumerate the Travel Act as one of its predicate racketeering acts. So it's right in the RICO statute that a violation of the Travel Act can be a basis for a claim under RICO. And what the plaintiffs here alleged was, or argued, was that a violation of the Anti-Kickback Statute constitutes a violation of the Travel Act. And because it's a violation of the Travel Act, it's a violation of RICO.
So it's pretty clear that a violation of the Travel Act is a viable RICO predicate. So to me, this case really comes down to the legal question of whether the Anti-Kickback Statute is one of the statutes that, if violated, can support a Travel Act violation. Do you agree with that?
Yes, and at least that's what the court said. And here it's helpful to quote just a little bit from the opinion. And the court said, quote, "To be sure, the plaintiff's reading of the statutes is somewhat circuitous, and it is unlikely that Congress would have anticipated it. On the face of the statutes, however, the theory seems plausible as long as a violation of the AKS counts as bribery, violation of laws of the United States within the meaning of it." So that's how the court framed the issue, and that's how the court decided it. And what the court then went on to say is this, quote, "Crucially, defendants have not meaningfully challenged that proposition. Given the absence of briefing, it is appropriate to leave the bribery question for another day, should defendants choose to raise it. For purposes of these motions, plaintiff's Travel Act theory at least gets out of the gate." So to paraphrase that, according to the judge, the plaintiffs convinced him at least to get into discovery in that case that when the Travel Act says bribery, it encompasses kickbacks in violation of the AKS. And it really sounds like the court did view this as purely a question of statutory interpretation. And it's interesting that the court said the defendants did not meaningfully challenge the plaintiff's theory on that point.
Yeah, I find that interesting too. The judge seemed to be correct that the defendants didn't really take on the statutory interpretation question that appears to be at the heart of this matter. They didn't offer the judge a textual or a legislative history argument for why an alleged AKS violation could not count as bribery under the Travel Act. So the judge was right that the defendants did not press the argument as much as perhaps they could have. Instead, what the defendants did seem to do is cite cases that say the AKS is not a RICO predicate itself, which it's not. It's very clear that it's not listed among the RICO predicate racketeering acts that are all enumerated in the statute. And they said it would be an improper, quote, end run around that list to allow an AKS claim to serve as a predicate via the Travel Act. But whether the AKS itself is a RICO predicate wasn't the question here. So those cases were not all that persuasive to the court. The plaintiffs were not arguing that violating the AKS constituted racketeering activity. They were alleging that violating the AKS constituted violations of the Travel Act, which we all know is listed in the RICO statute as racketeering activity and therefore qualifies.
So, Cal, since the judge viewed this as a pure question of law, are you surprised he didn't just fully decide the issue on the motion to dismiss instead of opening the door for the defendants to argue it again?
Well, it sure seems like he could have decided it. Both sides seem to agree that it's a pure question of law and could be decided without developing a factual record in discovery. It may be that the judge cut the defendants a break by allowing them to re-argue the issue on summary judgment.
Since the judge didn't fully decide the issue, what can we glean from his opinion?
Well, he does note that the plaintiff's reading of the statute is somewhat circuitous, as you quoted before, and he does point out that Congress likely would not have anticipated this type of argument when it was drafting RICO. If one were going to rule that plaintiffs were, in fact, doing an end run around the RICO statute, these are the types of arguments that would support that type of ruling. But it never came from this judge in this case, at least not yet. But let me ask you, Allan, looking at the briefing and the arguments that were made and the judge's reasoning, who do you think has the better case here, the plaintiffs or the defendants?
Well, I'm a defense lawyer, so obviously I have to come down for the defense here. But in fairness, I think this is a close question. The defendants here were all represented by top-notch firms, and they didn't seem able to come up with an argument in response, at the pleading stage that directly responded to the plaintiff's simple interpretation of the statutory language of the Travel Act. The main points the defendants stressed were that both RICO and the Travel Act have been around for decades and never been applied like this before. But if you're in a court that believes in a very textualist approach to statutory interpretation, like the approach championed by someone like Justice Gorsuch, I do think that those types of arguments are not necessarily going to be persuasive, and this theory could get some traction if the judge believes that the word bribery, as it's used in the Travel Act, furls under the Anti-Kickback Statute. So even under somewhat of a strict interpretation of the word bribery, it wouldn't be hard to imagine courts finding that a violation of AKS is bribery within the meaning of the Travel Act. That's because the crux of the AKS is a prohibition on paying for referrals, and it doesn't use the word bribery, but it's just not a tremendous stretch to get there. However, it's never been done before. This is a case of first impression, and it's a big change in the balance of the federal statute. So that's something that courts are going to have to really weigh carefully before they accept this theory that the judge here allowed at least to proceed to the next stage of the case. So I think bottom line is, we'll have to wait and see what this court does. The judge here expressly said he's going to reconsider the question, later on in the case, and also see what any other courts do, especially appellate courts, and if they follow it before we can really see which way the wind is blowing on this.
So the judge didn't explicitly rule here, at least not yet, that an AKS violation can be used to support a RICO claim through the Travel Act, of course. But the case is going forward past the motion to dismiss phase, suggesting that the defendant's end-run argument wasn't persuasive, at least not now. And that type of ruling, could be a big deal. The AKS covers so much of the healthcare industry, and as we discussed earlier, there is no current private right of action under the AKS. allowing this type of theory under RICO could be used by civil litigants to bridge that gap to some degree. And as we discussed, right now the closest thing to a private right of action under the AKS are qui tam lawsuits under the False Claims Act. But of course there are real procedural hurdles to those suits, such as filing under seal and seeking government intervention, being an original source, and then the materiality threshold under Escobar. RICO, of course, has treble damages and attorney's fees provisions, so it's an attractive statute under which attorneys might decide to bring suits and could theoretically create the type of cottage industry within the legal profession like qui tam attorneys have created who largely work on a contingency basis. Now, of course, there are other RICO elements that need to be present for this theory to work, the most critical of which would be the RICO enterprise requirement. But, Allan, we could do an entire podcast on that one, so we won't get into that here. With all of that said, my question to you is, practically, how might we see this play out? What healthcare environments and arrangements might be susceptible to the RICO elements, most notably the enterprise requirement, and who might some RICO plaintiffs be if we see more cases proceeding under this type of theory?
Assuming the theory of a RICO claim based on an underlying AKS violation does become recognized, yeah, then as you say, the question becomes what fact patterns might it fit? That's a broad scope of potential fact patterns there. If I were an enterprising plaintiff's attorney, I think I'd be scouring the case reports and looking for False Claims Act cases premised on AKS violations, trying to figure out how many of them I could relabel and refile as RICO cases. And I'm sure that others have had that thought too, and so we might see some of that. But there are some limiting principles as well, and some unanswered questions. So I'll just take a couple thoughts on that. First, obviously, there has to be a plausible anti-kickback violation. Given the breadth of the AKS, that leaves a lot of room. That's not terribly limiting in itself, since so many commercial arrangements in the healthcare sector have to be structured with the AKS in mind. There's a lot of potential fact patterns in healthcare that, if things are done incorrectly, could give rise to an AKS claim. Not necessarily an established violation, but at least a claim. But that could be almost anything in healthcare. It's as broad as there are types of business arrangements in healthcare given. So then I think the real limiting factors here are going to come from the elements of RICO itself, because it's not enough just to have a plausible AKS violation alleged. The claim has to meet all the elements of RICO, and there I'll just focus on one. I mean, I won't. As you said, there's enterprise and there's others, but the one that I'll just focus on here is damages. And even if there is a plausible AKS violation that's alleged, this theory really only works if there's a plaintiff that can plausibly claim to have been damaged by the AKS violation. So that's going to be right there a limiter. Maybe you could see situations where a competitor would say that, I lost out on business because one of my competitors was paying kickbacks under the Anti-Kickback Statute and I lost business as a result of that. That's possible. I mean, that probably is one of the more likely scenarios. One big unanswered question here is, what is the nexus that's required between the anti-kickback violation itself, which by definition is limited to federally funded business, and other commercial business that could potentially be the basis of a RICO claim. Does the RICO claim predicated on an AKS violation have to be for the very same claims one for one that the AKS violation affects, or is it more broad than that? And the defendants in this EpiPen case sort of started to make that argument, but didn't really go all the way with it, and the judge didn't really go down that path. But that's one of the examples of, if the top line theory is accepted, that's one of the key, I think, unknown questions that will have to be worked out going forward in order to really understand, how much of a risk does this theory and this line of cases pose, or how limited will it be to some narrow little niche areas.
Really interesting stuff, Allan. I'm sure we could talk about these issues all day, but I think we've pretty well covered this very important case. I want to thank you for joining me here today to talk about it, and I want to thank our listeners. Troutman Pepper represents a range of companies during criminal investigations and civil enforcement actions, including allegations involving RICO, the False Claims Act, the Anti-Kickback Statute, Stark Law, and other fraud and abuse laws and regulations. For more information about how we can help you, visit the Health Sciences and Litigation sections of Troutman.com. You can subscribe and listen to other Troutman Pepper podcasts wherever you listen to podcasts, including on Apple, Google, and Spotify. Thank you for listening, and stay safe.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.